What up, peeps? I thought I'd make this video to point out something that I happened to stumble across. And it's concerning an evidentiary hearing. Now I'm here in Georgia, the state of Georgia. The statute is OCGA 19-5-10, and it's concerning evidentiary hearings. I'm gonna read it. I'm just gonna read it. Duty of judgment is talking about duty of judge in undefended divorce cases. Appointment of attorney, evidentiary hearings, evidentiary attacks on prior judgments is actually A, B, and a C part of this here. So you can go look that up at your discretion, but I'm going to read the first part. Pretty much so you can have an understanding about what an evidentiary hearing is and what its purpose is. I think this would be a pretty good move for some of you who were never convicted. I mean, there was never any evidence on the record to prove any claim that was made against you, and there was a judgment made without evidence. An evidentiary hearing, in my opinion, would be a good move to try to get done. But let me just read this. Let's talk about in divorce cases right here. In divorce cases which are not defended by the responding party, the judge shall determine that the asserted grounds for divorce are legal and sustained by proof, or shall appoint an attorney of the court to discharge that duty for him. An evidentiary hearing for the determination of the existence of the grounds for the divorce and for the determination of issues of alimony, child support, and child custody and other issues is authorized but not required. If no evidentiary hearing is held, the determination of such matters may be made upon the verification. It shall be made upon the verified pleading of either party, one or more affidavits, or such basis or procedure as the court may deem proper in the discretion. So a lot of times, many times there are claims that be made going through divorce cases, and there's no evidence on the record to prove any claim that's been made. It was just in the original petition. And if you don't have any evidence to back up what you're saying, it's always good to use these types of hearings to present all your evidence. And it says it right here, different types of evidence or whatever. It's not just by affidavits, as it says one or more affidavits or such other basis or procedure as the court may deem proper in its discretion. So there's different ways you can prove your cases or whatever, but it's always good to have your evidence. See if you can get an evidentiary hearing scheduled so that you can present all of your evidence and put it all on the table so that a fair judgment can be made. Most people don't do that. They just kind of go through with it. I'm looking at it. I want to see if I'm not correct. I think there's rule 44.9. Let me see. Rule 44.9. Oh, the general rules. Let's see. Yep. 44.9. Let me see what it says. 44.9. Cases which were caused either did. Nope. This says something else. It's talking about something else. I don't want to get off the topic. It's talking about something else. But it's talking about cost. That's something else it's talking about. But anyway, I thought I'd make this video to kind of, so y'all can do more research on what an evidentiary hearing is about. I mean, it makes sense. I mean, just what it's called by itself is kind of self-explanatory. You're going to be able to present all your evidence so that the judge can actually make a fair ruling based on all the evidence that's been submitted into the case, okay, and presented in open court. So I thought it'd be a good idea to make a quick video on that. So go ahead and look into that, y'all. Emerald signing out.